Um, as you've heard, this session focuses on what has been a pretty hot topic in the last couple of years in the whole area of dispute resolution. Whilst inevitably much of the session is going to focus on adjudication, you'll note that our title refers to capping the fees of tribunal members, not just adjudicators. That gives us a rather broader canvas. Our panel will spend a little over 5 minutes each developing the topic with contributions that cover FIDIC and DAB tribunal fees, low value schemes that have recently been introduced in the UK, the alternatives to fee capping in other forms of dispute resolution, including arbitration, and finally, an African perspective, and indeed, to that extent, contrast with UK adjudication. The session is then going to develop into a more general discussion with the panel, and we'll try to take at least some of the questions, which I hope you will put to us using the online function. For those of you who don't know me, I was a solicitor for 38 years, specializing in construction law as a partner in both UK and international law firms before I set up my own practice. I gave up the practice of law in 2014 to devote myself full-time as an arbitrator and adjudicator. In 2015, I was the Chartered Institute of Arbitrators president in what was its centenary year. Before introducing the first of our speakers, let me set the scene a little with some background and I hope a degree of context. Fee capping in adjudication has been described by commentators in the last year as, and here's one, at last, cost capping on adjudication goes live. And UK Adjudicators' own adjudication scheme has been referred to as the ultimate fee capping scheme. So praise indeed. In adjudication, there are 3 types of cost for any potential referring or claiming party to have to consider. Firstly, the other party's costs. Happily, Section 108A of the 1996 Act, as amended, seems to have successfully protected the party wanting to raise a claim from having to pay the other side's costs of defending the process. So some certainty on that score. The second area is the claiming party's own costs, primarily those of their appointed representative. In recent years, at least in medium and small claims, fee structures have moved from the traditional hourly charging rate for different fee earners to a degree of fixed fee service and even no-win, no-fee arrangements. The third area of costs are the adjudicator's fees and expenses, where, despite the general premise that the loser should pay the adjudicator's fees, the statutory power to allocate fees and expenses as the adjudicator sees fit can create a significant level of uncertainty, with adjudicators charging between, say, £200 and £500 an hour. The adjudicator's fee invoice can easily rise above £10,000, which of course becomes a very significant issue for a small claim of, say, £50,000. Many commentators, and I have to say especially some of the firms that offer adjudication support services, put the size of the adjudicator's fees down to the formalization of the adjudication process over the last 20 years, which essentially has been formalized by the legal profession. And it is certainly the case that with many hundreds of TCC adjudication enforcement judgments, we now have a very sizable body of adjudication jurisprudence, which practitioners in adjudication have got to take into account when arriving at a decision. But I would suggest it's not all the fault of the lawyers, as party representatives, in my experience, often seek multiple rounds of submissions that a TCC judge would never permit in court. And we have to do it, of course, all in 28 days. The issue of adjudicators' fees was looked at by the Department of Business, who it appears suggested to the nominating bodies that they, rather than the department or Parliament, should find a solution to the problem. And the solution that has arrived is to cap the adjudicator's fees, especially in low-value disputes. One problem with this solution as most adjudicators will indeed point out, is that there may be almost as many documents and complexity in argument in a dispute with £50,000 at stake as there is with a dispute with £5 million at stake. This often makes it difficult for the arbitrator to provide the decision with a fee that, when looked at commercially and proportionately, makes sense. Some have suggested that adjudicators simply rack up the hours. I think this is unfair. Indeed, anecdotal evidence suggests it is not uncommon for adjudicators to discount a perfectly reasonable time value spent to arrive at a fee that the adjudicator feels is commercially proportionate. Another problem area with fixed fees is where the dispute does not ask for an award of money. Over half of my adjudications in the last 5 years have been for declaratory redress and not for cash. Let me finish with two observations that arguably don't sit very comfortably together. The success of ADR procedures generally, but especially construction adjudication, depends on the support of those who pay for it, the parties. And they, of course, are entitled to get value for money from all the professionals involved, including adjudicators, party representatives, and indeed nominating bodies. The fees the parties have to pay have got to be commercially proportionate to what is in dispute. The second point, though, is the essential nature of at least UK construction adjudication, a 28-day process leading to a decision which, whatever Parliament may have intended, is more often than not a finally binding decision that the parties have to live with. In a pretty small proportion of decisions that are challenged in court, a tiny proportion of those are not enforced. And I would suggest that the reason for that is that the general standard of decision-making is high. If the quality of the decision-making goes down because the fees available are not commercially realistic for the senior practitioners to accept nominations, then there must be a risk the proportion of decisions enforced will also reduce. If that were to happen, the paying parties will have a lot less certainty and confidence in the whole process of adjudication. Those of us involved with construction disputes when statutory adjudication arrived in May 1998 will remember what happened to domestic construction arbitration, which had been the favoured means of resolving disputes until that date. Domestic arbitration in construction disputes reduced by about 90% overnight. So we need to remember that things can change very rapidly and not always because of reasons we want. So in my humble opinion, it's always going to be the paying party rather than the practitioners or indeed the judiciary who determine how commercial disputes are resolved, and we should never forget that. Anyway, enough of my rant and my comments, and indeed of the background. Our first speaker is Adriana Spaceover, a civil engineer with 35 years professional experience and more than 20 years FIDIC experience, including as FIDIC arbitrator and dispute board member. Adriana is a member of the FIDIC President's List of Approved Adjudicators, a member of the FIDIC Contracts Committee, founder and chair of the Bulgarian Society of Construction Law, and the current president of the European Societies of Construction Law. Adriana will give us the FIDIC DAB perspective on fee capping.
Thank you, Charles. I'm honored to be here with you. First of all, I would outline several differences which are important in relation to the topic between the statutory adjudication and the FIDIC dispute boards. First of all, the referral in the statutory adjudication is strictly for one dispute. Of course, we can have the snowball rolling downhill, But anyway, when we have a referral to the dispute board, especially when it is not appointed in the beginning of the contract, usually we have several different disputes. Also, another difference which is important is the time for the decision, because it is 28 days for the statutory adjudication, while in FIDIC it is 84 days. Also, it is very important to understand the preventive function of the FIDIC dispute boards, because the ad hoc dispute boards, which were common in the 99 edition for the design build contracts, now have been abandoned. And now I shall compare only the standing dispute boards with the statutory adjudication. So this preventing function is working with site visits, informal assistance, which is done during the site visits and in between. Also, another important difference related to the cost is that in FIDIC contract, each party pays half of the bill. So half of the remuneration for the dispute board is paid by each party, and the adjudicators cannot change this. While, as we just heard, in statutory adjudication, the adjudicator may be empowered by the contract to allocate fees and expenses. So now, what are the provisions in the 2017 edition? We have a monthly fee for the dispute board members, and we have also the daily fee. The monthly fee is the retainer for the dispute board member being available, being informed, archiving the relevant documents each month, and some office overhead expenses. It was argued, for example, by the esteemed Gordon James, that the parties should not pay to someone who is not doing any services related to the retainer. But now the new edition says that if there is a zero monthly retainer, that those matters will be distributed in the daily rates. Actually, I think that since we have seen the benefits of the virtual site visits and virtual meetings, in future, maybe there will be each month a virtual meeting, and the site visits will be, let's say, 3 times per year, because now they are presently 3-4 times per year. So the daily rates are the important one in the end. And also, of course, there is a payment of the expenses related to travel, accommodation, and so on. So the members submit their invoices for payment of the amounts to the contractor. The contractor pays the amount in full, and then half of this amount is reimbursed with the other payments, the usual payments, which are done monthly usually. If the contractor fails to pay within the term of 28 days, then the DAB member may inform the employer, and the employer then has to pay the full amount and deduct half the amount. So this is the procedure, which is very straightforward. And now we have an interesting provision. If the parties and the DAB member have agreed all other terms of the agreement except the fee, in this situation, one of the parties can ask the appointing entity, because in the contract we have an appointing entity or official. For example, this is usually the president and FIDIC. This party can ask this appointing entity to set up a reasonable fee. And it is interesting how the provision explains the reasonable fee. So this reasonable fee shall take into account the complexity of the works, the experience and qualification of the DAB member, and all other relevant circumstances. So what are these circumstances? This can be different. For example, now with the new certification program, we expect about 400 adjudicators to be certified, because now we have about 60 people on the FIDIC president's list. So it is interesting whether in future the standard of the country where this adjudicator is working will be taken into account, because this is important for the rate, whether it is reasonable or not. In the end, the appointing entity can set this fee, and this amount will be final and conclusive. Talking about the cap, in my opinion, a cap for the dispute avoidance activities will help, because the dispute boards are appointed in the beginning of the contract, and in the tender documents, the employer may include half of the amount, which is for the standing dispute boards for its dispute preventive functions. It is easily calculated. And even now, when we don't have a cap, we have this option, because we have the published rate for arbitrators appointed by the International Center for Settlement of Investment Disputes, which is part of the World Bank, which is $3,000 US per day. And I see that mostly the adjudicators are within this rate, adjudicators, but sometimes, for example, adjudicators from the FIDIC president's list go up to 3,000 euro. So now we have many more adjudicators which will be certified. So I think that even without a cap, they will be within this amount of $3,000. So now we can easily calculate what is the budget for the standing function, which will be, let's say, 1 day per month for the retainer, and we can cap the days for the site visits, because they depend on the location of the site. They can be kept to 10, 12 days annually, and we can have this budget. As in relation to the dispute resolution, let the parties share the pain, because they have the opportunities to have this informal support of the dispute boards. They can have opinions, they can have interpretation, and also they can use this mechanism so that disputes do not escalate. So when the time comes that something cannot be resolved, the disagreement escalates into a dispute, let them then spend these amounts of money, because many times parties complain that the costs for the legal representation and forensic experts are higher even than the dispute board costs. Otherwise, for the disputes, we cannot estimate any cap, I think, because, for example, this year I was working on 3 decisions, and one of them, the documents reviewed were less than 100 pages. Another one was more than 10,000 pages, and the amounts of the dispute were from differing 2,000 times. So it is always different, that not only the value, the amount of the claim, as you said, sometimes there are elements which are not related to money, there are disputes which are not related to money. So in my opinion, the conclusion is that a cap is possible for the daily rate to help to prepare the budget for this dispute prevention role.
Thank you very much. I'm sure we'll come back to that, because there's some interesting differences, I think, which, but nevertheless, some things we may be able to learn from the DAB procedures. Our next speaker is Syrian Nolatamby. a senior associate solicitor at the Chelmsford-based law firm Birkett Long, and he specializes in construction law, especially dispute resolution. He's represented clients in more than 100 adjudications. In addition to the UK Adjudicators panel, Suryen is a panel member and panel adjudicator with the RICS, the Chartered Institute of Arbitrators, and CIC. He's going to concentrate on the recent growth of the low value fee capping schemes that we now have in the UK in the adjudication arena. Over to you.
Thank you for this introduction, Charles. Hello, everyone, and welcome to this panel session of this morning. What I'm going to talk about is the recent low value capping scheme in UK adjudications. Like Charles said in the main introduction earlier, this was a long awaited thing to happen, to really look at how, that third part of looking at how parties can have cost certainty when they are referring a dispute to adjudication. And there has been, adjudication was meant to be to reach a fair, rapid, inexpensive decision on any construction disputes. And 25 years now since we've had the Construction Act and having adjudication. With my own experience, I can say before, say, 2019, 2020, and last year, there were huge criticism about adjudicators' fees. That would start where you have especially small value disputes, anything between 15 to 30,000 pounds, I would say, where you will go to a successful adjudication and then you find yourself having to pay adjudicators' fees, which could be 10,000, 15,000. And there were no clear parameters of how adjudicators will be looking at controlling their fees, or there's no certainty how many hours will be spent by an adjudicator. Usually an adjudicators in UK adjudications, their hourly rate could range anything between 200, 250 pounds up to about 450 pounds per hour. That's from personal experience. But then again, you will find small value disputes where the fees, like I said earlier, could be anything between 10 to 15,000 pounds on an adjudication. Whereas other adjudications, which are fairly simpler in nature, in my experience, say 150,000 pound in dispute for a final account, yet that adjudicator who could have a rate of 400 pounds an hour, but his final bill for the adjudication, I think this is all about experience as well, could only be about 6,000 to 8,000 pounds. So it's very uncertain how do you, if as a party representative, to advise your client about, oh, okay, fine, you're not going to pay the other side's costs in an adjudication, and this is your cost certainty, this is your cost budget to run this adjudication. Then when it comes to adjudicators' fees, there were these issues about, wow, we got this bill. Very welcoming, like everybody said, I'm going to look at 5 main adjudication nominating body in the UK who have changed things for service users and especially people who are behind those disputes. That includes the TEXA, the CIC scheme, the Construction Industry Council, which was taken on board by the CIARB, the RICS, the UK adjudicators, and also I'll touch on the LCIA, who had last year brought cap fees for arbitrators. Well, TEXA had a pilot scheme in 2019. They ran that successfully, and to be able to bring cost certainty, I'm not going to read everything about what the range are, but basically there were cap fees up to claims for 100,000 pounds. For them, that's small value, and the fees will start for 2,500 up to 5,000 pounds, various tier. But one thing was, a referring party will normally use a particular form to refer a dispute, and there's no requirement for the opposing side to actually consent to the low value dispute scheme. And there are other, restrictions. For example, if it's more, it has to be a claim for money. For example, retention or default payment. But if it is regard to, for example, assessment of damages or loss and expense claim, then the low value disputes might not apply it for TEXA. So that's when what about TEXA is concerned. Then you have the CIC scheme, which brought what they refer to CIC LVD map, the model adjudication procedure. And here the fees are actually fixed. Again, it means you pay anything between 2,000 for disputes up to £10,000, and that rises to £50,000 is the ceiling, where you will be paying fees up to £6,000. Anything over that, that's negotiable between the adjudicator and the party referring, or both parties. And adjudicators' fees for site visits and meetings are capped at £1,000. The issue here with the CIC, which has been, like I said earlier, been taken on board by the RICS and the CIRB, is normally it requires the opposing party to consent to that procedure. So what happened in practice is a referring party uses a specified form saying, okay, I would like an adjudicator to be appointed under the LVD map procedure. If you got an opposing party who does not consent to the procedure, that's it. The adjudicator has got a, doesn't need to apply the fixed fee. He will charge an hourly rate of the actual time spent. There's another issue with that as well, is if, for example, irrespective of the hourly rate, the number of hours actually spent by an adjudicator to produce a decision is less than the £6,000, for example, for a dispute of between £25,000 to £50,000. It means because it's a fixed fee, the adjudicator is entitled to.
I'm speaking.
Yeah.
I'm the last speaker of the day at 6 p.m.
Can you guys hear me? Yeah, so the adjudicators, because the fee is fixed, can still charge the £6,000, for example, plus VAT for that adjudication, irrespective, even if the time actually spent would be £3,000 or £4,000 for that particular this sort of adjudication. So that's something which will probably come up in the future, but that's from personal experience. Recently, I've noticed where this kind of disparity will happen. I'm not going to go into detail with the CIRB. They've adopted that in last year in 2020. Similarly, the RICS has adopted the same scheme with similar fixed fee scheme. But the final one I'm going to do, or before the final one, would be the UK adjudicators. I mean, all these details can be found on the various institutions' website. But UK adjudicators brought something fairly new, which I'm just doing a comparison here. All the fees are capped. So if it starts from 1,750 right to £10,000 for dispute up to £250,000. But then you have a daily cap of fees that can be incurred by adjudicators, which is just over £2,000 plus VAT. And if it's a declaration only adjudication, these are capped at £5,000. With the UK adjudicators and together with the TEXA, here again, you do not require the opposing party or the responding party to actually consent to the procedure. So you as a referring party, you can use that scheme, for example, and you know where the fee ceiling will be. And if the adjudicator has spent less time, obviously they will make, I mean, from experience, I don't think adjudicators just rack up fees. Most adjudicators now, would actually do what's more commercially proportionate to the value of the dispute. Then finally, looking at LCIA, not strictly to do with adjudication, but arbitration. In December last year, they brought a capping fee for tribunal members, where the hourly rates cannot exceed £500. Emergency arbitrators, for example, £22,000. I'm going to stop here to let my colleagues speak to you on their side, their topics, and then I will participate in the major, discussion panel to bring a bit more experience of my experience about fee capping and fees being charged by adjudicators. Thank you.
Thank you, Suryen. Dean, as a practicing adjudicator, I think it's time for you to respond to the criticism that the poor old adjudicators are coming in for here. Dean, for his sins, is a registered adjudicator on the panels of not just UK adjudicators, but Chartered Institute of Arbitrators and CIC. And if that wasn't enough for him, he's represented over 100 rather, he's representing parties in over 100 adjudications. So, Dean, over to you for the spokesman for the defence.
Yeah, good morning, everybody. I hope everybody's well. Okay, on the issue of capping the fees of the tribunal, a controversial statement perhaps, but in my view, adjudicators' fees are actually not necessarily the major issue and are not prohibitive in any way to adjudication or the use of adjudication at all. In my experience, adjudicators' fees are generally reasonable, even where hourly rates are high. The high rates are usually commensurate with the experience of the adjudicator. With experience, obviously, comes efficiency. So experienced adjudicators are generally more efficient, and so where they do charge higher hourly rates, then I would suggest that their fees are no higher than those for a less experienced adjudicator on a lower rate. So in essence, having represented parties in over 100 adjudications, I think there's only one or two instances actually where I have thought to myself, these fees are excessive. In some instances where we've had what's termed a kitchen sink adjudication, so a big final account adjudication with a lot of quantum issues and points of law at stake. This particular adjudicator, very experienced, actually came in. Fees were about £14,000 or £15,000, but I was expecting a lot more than that, given that the referral was bulky, as was the response, and the reply was even bulkier than the referral. So he'd done a good job, and the fees I thought were lower than they perhaps were going to be. Again, no issue there in my view, and I've found that to be the case in the majority of adjudications that I've represented parties. And yeah, it's few and far between really. So it's all very well that we're looking to reduce the costs involved in adjudication and singling out adjudicators' fees, whilst they may, in some instances it may be of benefit. I'm not sure it really gets to the root of the problem really. My view, rightly or wrongly, is that the party costs are quite possibly the most prohibitive aspect of taking part in an adjudication. Firstly, if you've got a good or strong case, then really you shouldn't be too concerned about the adjudicator's fees, because if you're going to win, it's likely that the other party will have to pay the adjudicator's fees. So therefore, it's really your costs that you need to be concerned about. Yes, so yeah, your costs, and obviously the other party has to consider their costs, and I would suggest that they're the most prohibitive aspect of adjudication, and that's quite probably because the process over the years has morphed from something that was perhaps supposed to be relatively straightforward or simple in the beginning, and it was, so I'm told by adjudicators who were practicing in the mid to the late 90s. And it's morphed into what is in effect a fast-track and fairly complex legal process with irrecoverable costs, unless, of course, the parties agree that costs should be recoverable. once a notice of adjudication has been served. So rather than focusing on adjudicators' fees, whilst admirable, and it may have, don't get me wrong, you know, in my view, it may have uses, its uses in certain circumstances, but perhaps there should be some focus on addressing the matter of parties' costs. Now, obviously, parties' costs are a matter for the parties in essence, really. But how could we, you know, I know from talking to a number of you speak to a number of subcontractors, you know, on a regular basis, and one-off phone calls that, you know, come out of the blue from various contracting parties, and you know, they always, the word on the street is that you know, it's not worth referring to adjudication, you know, because unless your claims over, let's say, £100,000, because you know, you'll rack up at least £20,000 in fees with lawyers or other representatives. Now, that may be the case depending on who your representative is. You know, I cut my cloth to suit depending on what the dispute actually is, and try and offer my clients good value as a representative, and I imagine many others do. But you know, look, ultimately, it's not an inexpensive process, and therefore, how is there anything we could do about that? So, in conjunction with the you know, the cap fee schemes that are the low value schemes which are in circulation at the moment or in use, you know, I'm not suggesting for a minute that they should be discarded. But you know, I'm looking at other ways that perhaps could work alongside that, and party costs, addressing those being perhaps one way of addressing costs of adjudication as a whole. So how could we do that? Perhaps we could look at making some ways of making costs recoverable. The party costs are recoverable for any time wasted on unfounded jurisdictional challenges. I've had one particularly stressful experience of jurisdictional challenges where, representing a referring party, the responding party had 3 lawyers actually operating or acting for it, and I'd served the referral, and after that, obviously, wanted to get on with my other work, and in the morning I had a jurisdictional challenge from one of the lawyers, deal with that make a submission to the adjudicator on that point. In the afternoon, there would be another one from another lawyer at the same firm, and in the evening, there'd be another one from another lawyer at the same firm. Now, this went on over a number of days, and none of them were well-founded. You know, they were just trying to make the process as difficult as possible for whatever reason, and ultimately, we did go on and obtain a successful we were successful in the adjudication and got a decision in our favour, in my client's favour. But the question is, of course, then the costs of dealing with all of those unfounded jurisdictional challenges was not insignificant. You know, my client had to bear that cost for me dealing with it. So, is there some way we could do something about that? Also, could we look at repealing the part of the Act which essentially prohibits all costs from being recovered in adjudication? And perhaps revise it to only prohibit clauses which apportion all costs to one party in a contract. So, you know, prohibiting tolling clauses. Perhaps if party costs were recoverable, you know, and they lie where they fall. Sorry, the cost follow the event, should I say? Not lie where they fall. You know, the adjudicator is to assess those costs. And perhaps have to take a reasonable view on them. So, if party costs were to be recoverable, if we repealed that part of the Act, then you know, you can get an imbalance of power where you have a party, a large company with a lot of money. They will perhaps use a sledgehammer to crack a nut and front the adjudication with QCs, etc. You know, and that will obviously have the effect of intimidating perhaps a much smaller party, who, if it was not successful in the adjudication, could be faced with a really large bill for what, in essence, was not to that complex a dispute. So, if we were to repeal that part of the Act, could we look to adjudicators to take a view on costs? So, if a party has used a sledgehammer to crack a nut, for want of a better phrase, could the adjudicator say, well, looking at the dispute and the party involved, I have the power to award costs. But I have to assess what's reasonable in the circumstances, and then take a view on those costs. So, you know, that if the large company, you know, the large company with significant funds did use a number of QCs and adjudication, which was relatively straightforward and didn't need that, you know, that kind of might behind it. It's to run its arguments. Perhaps the adjudicator could, you know, significantly reduce those costs on assessment, and therefore it would discourage that kind of behaviour and reduce the concerns of parties having to, you know, being borne with the other side's costs. I think majority of adjudicators are experienced practitioners themselves and practiced as advocates prior to becoming adjudicators. So, you know, they are more than capable of taking a view on what would be reasonable in the circumstances. And then that would obviously give a referring party some comfort that if they were successful, not only would they recover their own costs, provided they're reasonable and the adjudicator considers them to be reasonable, but, you know, they if they weren't successful, then they wouldn't be liable for a sum out of all proportion for the other party's costs. And of course, you know, this would place a big emphasis on adjudicators to decide what's reasonable and what's not when taking all of the facts into account. But it would reduce concerns, because surely recovering some costs when you're successful in an adjudication would remove the concern that if you're successful, it's going to cost you a lot of money in your own, you know, in your own party costs, and you can't, you know, you can never recover those. So there may be something there, perhaps, that could be looked into. And just having a look around LinkedIn and comments on certain threads on there regarding the low value scheme recently, there are other people that suggestions that I've seen that have come out are significantly reducing the cost of nomination. So the nominating bodies to reduce their fees. Now, I know UK adjudicators obviously have a free nomination service. You know, can some of the nominating bodies look to do something similar or significantly reduce the fees? You know, somebody suggested to under £100. And another suggestion was that a decision could be reached quickly within a week or less to aid cash flow. And another suggestion was a decision given in no more than 2 pages with a cap of 2 hours fee work. So, you know, those the last few suggestions there are in relation to obviously capping adjudicators' fees further. But my view would be that whilst that's admirable, and I'm not suggesting to dispense with it, perhaps we should be looking at the bigger issue, which is party costs in adjudication, because that, in my experience, is certainly the most prohibitive aspect of parties wishing to use adjudication as a method for resolving disputes. And that's it from me.
Right.
Somebody else.
Thank you, Dean. A very robust set of proposals and suggestions there, if I may say so. A couple of very short observations. You, as an adjudicator, you know you're in trouble when 5 minutes after you tell the parties, "Hi, I am your adjudicator," you get the first letter in that says, dear adjudicator, this is jurisdictional challenge number 1. Because then you think, oh, wonderful, just how many am I going to get then? And the most I've ever had is 7, which is quite interesting. And they went through the gamut of all the jurisdictional challenges, and each one was probably had less merit than the one before. Similar point, you mentioned if you like, the need for the party representatives to play their part in keeping the adjudicators' fees down. I mentioned in my opening pleadings, I've recently had an adjudication where the parties went through statement of referral notice, response, reply. Oh no, that wasn't enough. We had rejoinder, surrejoinder, and then rebutters. And in 38 years as solicitor, I never came across rebutters. We used to use different coloured inks for all sorts of amendments to pleadings and things. Now, if I was, not that I'm ever going to be a TCC judge, but if I was, nobody would come before me and dare to suggest anything like it. There is no reason why you should not set out your case in one go and the other party its response in one go and limit anything else to new issues arising out of the defence. And that, of course, is something that we do as adjudicators have the power, because we have the power to run the procedural side of it as we wish. We have the power, and I don't think any court would ever criticise us on grounds of natural justice if we were to stick much more rigidly than actually we normally do to the need to get it done in 1 or 2 bites, not 6 or 7. That's one of my rants. Anyway, we move on, because we're going to move on now to a slightly broader view. Seamus O'Doherty is the Director, Global Construction Practice at international consultancy Berkeley Research Group, LLC. BRG is in a very unique position that it is one of just 3 firms who have been placed in the first tier of litigation support category within the well-known and renowned Chambers legal directory. So when it comes to assisting parties in getting claims ready for adjudication, or indeed any other form of dispute resolution, it's Seamus and his team who are likely to be, on many occasions, will be helping to do that. Seamus is going to look at the fee capping in dispute more generally, with I think probably some emphasis on arbitration, which will give us a useful comparison between adjudication and arbitration practice. Seamus, over to you.
I'll unmute. Okay, thank you very much, Charles, and thank you for the UK adjudicators for asking me to talk today. Yeah, as Charles said, I'm going to be looking at pretty much broadly at costs, fee capping in ADR. So the first thing really we're going to look at, and I'll probably just do this on a graduated level, which I'll look at probably arbitration as being the highest. So I think we've got to remember tribunal fees are part of the costs components in arbitration. Yeah, they're not insignificant, but just from an ICC bulletin issued in 2015, issue 2, ICC said that the adjudicators' costs were roughly 15% of the overall arbitration costs. Party costs sat in at 83%, so that would obviously be legal fees, experts and the like. And then you obviously have the ICC administrative expenses. So it's not insignificant, but I think I just want to raise the point here that when we look at international arbitration, obviously the sums are larger and the parties are, well, they will be more experienced, and you more or less know what okay, there is flexibility. You will know what the procedure is going to be. So parties understand it's 15%, so it's a larger sum. So the sums, but then when we kind of come to adjudication, which I will get onto now in a moment, it was supposed to be a fairly fast track for resolving payment processes. So you get it from a gambit of anything from 5,000 up to wherever you want. So obviously on the smaller elements, the percentage fees for adjudicator, the tribunal fees may actually be a lot higher than 15%. But anyway, I'll come on to that in a moment. But I just want to go on and look at, well, most arbitrations are run with arbitral institutions. There are obviously ad hoc arrangements, but I'm just going to set out roughly how the tribunal fees are established. The ICC, they do an ad valorem basis, which is essentially they look at the value of the dispute brought between the parties, and they have a very helpful calculator on their website where you stick in the value of dispute, whether it's going to be a sole arbitrator, whether it'll be a panel of 3, a tribunal of 3, and you can put that in, and it will spit out an answer approximately as to what the cost will be. And they say under Article 38 of the rules, the fees are calculated with reference to the time spent and the value of the dispute. So ad valorem. But regard is also given to the complexity, diligence, sufficiency, and time spent for the arbitrator. So again, there is some kind of inherent capping. So whilst there is a broad kind of brush approach, there is flexibility in them being able to not only look at the cap, but tweak it a bit. Okay, so we come on to the LCIA. The LCIA take a different view. They look at an hourly fees. So the tribunal fees are set out rates which I think from October 2020 went up from 450 an hour to 500. So they won't exceed that in exceptional circumstances. It says here the fees are calculated with reference to the time spent and the rates fixed, along with circumstances such as the complexity of the case and the arbitrator's special qualifications. So the LCIA, again, are trying to, whilst it's an open-ended hourly rate, they are also trying to ensure that looking at the dispute, that the hourly rate isn't excessive and so on. So there is an element of capping in that. Then I look at the Hong Kong International Arbitration Centre. They have a choice between ad valorem and hourly rates, and it's up again. Obviously, with arbitration, it's a consensual process, so the parties kind of choose whether they look at it on the value of the dispute or look at it on the hourly rate. There is a cap on the hourly rate. The $6,500 Hong Kong dollars per hour is the cap on that. And then we have the Singapore again. Singapore has an ad valorem, so it's based on the value, but also there is flexibility again in the rules to allow the parties to agree and determine the tribunal's fees in consultation. There's also so to go back on that, whilst they're not necessarily, well, the ICC do have caps and so on. So there are certain fees in that. The American Arbitration Association also, I think it was in 2018, set up alternative fee arrangements. So what they're again trying to do is give cost certainty to the parties. And this is currently available for two-party commercial and construction cases, utilizing a single arbitrator following either the regular track or large complex case track. And there's two ways of doing this. One is the fixed fee arrangement. The parties and the selected arbitrator agree to set an overall fee for the case, divided into fee segments for the pre-hearing, hearing, and post-hearing phases of the arbitration. So that's one way of doing it. And then the next one is they actually have a capped fee arrangement whereby the parties and the selected arbitrator agree to a maximum fee for the entire process, but the actual arbitrator is paid on the hourly rate and is billed up until the cap is reached. And then obviously that's the risk inherent in taking on a capped fee, is that if you exceed your hours, well, you live and die with it. I suppose the bonus on that one is if you don't exceed it, well, then you may have some sort of benefit. But in my experience, a lot of these cap fee arrangements, it is quite difficult not to spend the hours, because, especially if the documents are so poorly presented. So that's really a couple of ways, the main ways the arbitration is dealt with. There obviously are ad hoc arrangements as well. If I then come on to adjudication, the UK adjudication, statutory adjudication, there isn't any cap on the fees. Again, it's a contractual arrangement between the parties, so they could agree with the adjudicator to cap the fees. But I just want to go back and look at what is the situation if there isn't a capped fee. Well, paragraph 25 of the Scheme of Construction Contracts, England and Wales Regulations 1998 as amended, says the adjudicator shall be entitled to the payment of such reasonable amount as he may determine by way of fees and expenses reasonably incurred by him. So there isn't any cap there, save for the issue of reasonable amount. Now, it is quite difficult if you're a party who's, let's say, had a decision and the adjudicators found against them, and it's obviously cost follow the event, if that's the way it works, for them to argue that the sum of money is unreasonable, because the courts will very reluctant to find that, and it is quite difficult. I probably will touch upon one or two of the low value disputes that Suryen didn't discuss, which I'll come on. But I think the interesting point in what Dean said as well is that in adjudication, when we go back to the old days, when it was coming in to replace arbitration, it was very much a streamlined process where, especially in construction, there was a lot of QSs who were quite happy to do it, and then it morphed into a very legalistic approach. and to take on board what was previously said. I've just done two recent enough adjudications, and both of them small enough matters, but jurisdiction challenge. So it really is the parties. When you look at the fact that why are adjudication expenses, adjudicators' fees quite expensive? Well, I think the parties need to look at themselves and ask themselves the same question. Should they be raising these jurisdictional challenges? Granted, it is obviously up to them to do whatever they want to do, but they can't then look back and ask themselves the question, well, why did the adjudicator why were the fees? Because it was a relatively simple matter, let's say a smash and grab or a procedural adjudication, and then surprisingly enough, the parties lose. But you've had one or two jurisdictional challenges which you've got to deal with. Well, that's obviously going to rack on the fees. But so you're then left with the invariable situation that you take on board the fact that it may be a certain sum of money. You look at the hours you spent. You might cut back some of the hours because you do have to be reasonable, and you take a commercial view on it. So just really on the fee capping in adjudication, under the UK statutory thing, there isn't any fee capping, and I really do think in the big scheme of things, it is a question of looking at the amount that you're actually trying to adjudicate, and getting the parties really to participate in a good, almost a good faith way, which is unfortunately the reason why sometimes they've actually gotten down to the road of a dispute, is that they can't talk to each other. So that is probably me asking for the impossible. I'm just going to touch upon the RCS they've obviously signed up as well to the low value CIC model, but they do something. It's an RSS, it's a summary adjudication, which is a 14-day process, which is very much again the idea is, again, the parties have to agree to it, but the idea is that it will help to assist the cash flow quite quickly. So what the timetable for that is, begins the day the adjudicator receives the referral. The respondent has 7 days to respond. Referring parties 3 days to reply to the response, and the adjudicator issues a decision within 4 days. So again, the fees are capped at 1,000 plus VAT, and the nomination fee is £300. Similarly, the CIR and the CEDR, Centre for Effective Dispute Resolution, came together and did something called Pandemic Business Dispute Resolution Service, where it's a process. It's a bit of a mix where they offer facilitators, mediators, and there's also fast-tracked arbitration, and it's suitable for disputes between 5,000 and 250,000. Cost dependent on the option taken. For example, if it's the arbitration, it's 1,250 plus VAT per party. It takes about 90 days or less, and it doesn't include a hearing or site visit. We also, in looking at, obviously I'm looking at ADR, so ADR isn't just arbitration adjudication, and we can go on to mediation as well. CEDR, again, have a fixed fee mediation scheme, which they've graduated within the amount in dispute. If it's 75,000, CEDR selects and appoints the mediator for £600. The parties choose an eligible mediator, that's another 600. And then they effectively get 7 hours for mediation. So extra hourly charge for people after 7 hours of mediation is 120. And that graduates to 75, 125 and 250. So the industry, I think, generally is alive to the fact that parties in dispute, especially lower value disputes, there aren't open checkbooks. So the industry, as I say, is alive to that and is trying to facilitate the resolution of these issues, because I think there's a wider issue as well, because obviously with the courts become pretty clogged up as well. So it really is in everybody's interest to try and find a reasonable, sustainable cost methodology whereby disputes can be resolved and not allowed to fester, because ultimately we must remember commercial entities, whilst they may not enjoy having a dispute, and it takes and sucks up a lot of the energy within parties, organizations, I think once they get a reasoned decision, quite often they mightn't like it, but they move on. So I think we need to ensure that we can, we as an industry can facilitate that. Okay, and there are, but again, I've really kind of tailored this little canter through commercial aspects. There are obviously the likes of consumer adjudication and arbitration processes, which you can and quite often it's a good area whereby budding dispute resolvers can get blooded, let's say. The likes of ABTA or CEDAR have various things and so on, which again, the cost to the consumer is either nil or it's fairly low. I think the likes of the ABTA one is £107 or £130, depending on the value. The CEDAR have one in relation to the RSS, where it doesn't cost the complainant, i.e. the customer, or anything. So, so I suppose just to summarise, in arbitration, really, especially mature arbitration, I personally don't think the arbitrators' fees are that high relative to the process, and I think the parties in international arbitration, especially, they understand that, and they essentially want people with the right skill set. So I think whilst you can tweak it, and I think it's like anything, if you get good arbitrators who can actually streamline the process, that's where the cost is, because remembering there's 83% of the costs are in party costs. So if you get good arbitrators who can actually streamline, that's good. And in adjudication, looking at it, it really is up to the parties, because the adjudicators ultimately, and being an adjudicator myself, we do always end up with a situation where we look at the value of dispute, and it becomes, you then have to obviously look at that fact that you get all the submissions, and sometimes I think the parties, again, depending on the level of their experience, kind of expect an adjudicator to try and unravel or extract what exactly they're saying. So if the parties spent a bit more time in preparing it and asking themselves the same sort of question of, well, what exactly am I saying here, and not have reams and reams of documents which aren't really that relevant, I don't think the adjudicator's fees would be that big an issue. But although, as I say, in a lot of instances, it becomes quite an issue when we're looking at small dispute fees. I think, Charles, that's really what I'm going to say. So I'll stop.
Seamus, thanks very much. That was a very rounded and comprehensive analysis, I think, across areas other than simply UK adjudication. I apologise to those who were expecting a nice lengthy panel discussion. It looks as if time's going to defeat us. But Damian, if you could be as brief as possible, we might have time for one or two questions. Damian James is a leading expert in quantum, delay, disruption, and cost evaluation in the construction industry. His firm is based in Johannesburg, with offices in Durban, Dubai, London, and Manchester. Damian is going to give us an insight and perhaps a comparison between the use of fee capping in adjudication and other forms of ADR in Africa as compared with the UK. Damian, over to you.
Thank you, Charles. Thank you for your kind introduction. I'll try my best to keep it short and brief. Obviously, the difficulty with going last in a panel is that most things have already been said, and we've heard from a very stellar lineup today, leaving me very little to discuss, but I will try to place an African perspective on it. As Charles mentioned, I'm a delay and quantum expert, but I also act as both an adjudicator and arbitrator. I say at the outset, in terms of my thesis, that increased costs in disputes are often a consequence of the parties' conducts. I will expand on that slightly later, but it's been a common theme amongst my fellow panellists. As I've said, matters that I undertake are in the UK, Africa, the Middle East, and Europe, but I have a little bit more of an Africa-centric focus in my discussions today. As a precursor, and given the kind invitation of the UK adjudicators, it's necessary for me to explain that adjudication in Africa is available to the parties to a contract, and this is a contractual adjudication, given that there is no statutory adjudication available. In South Africa, contractual adjudication is available to the parties, with many contracts using the South African JBCC and also the NEC forms that many of us be familiar with. The nominating bodies for adjudication appointments are the Association of Arbitrators and the Construction Adjudication Association of South Africa, also known as CASA. For those that follow the African profile, you'll have noticed that in Kenya over the last 12 months, there's been developments in respect to the JB contract, and that's allowing contractual adjudication. And there's been a positive move to dispute resolution in Kenya and definitely in East Africa. When we return to South Africa, CASA is considering low dispute value adjudication schemes, and we've heard on those today. They'd be very much similar to those in the UK, and it'd be a significant benefit to the dispute sector in South Africa. The history of dispute resolution in Africa itself has had and continues to have a heavy focus on arbitrations, and that's been the common choice for dispute reconciliation. In my experience, these arbitrations have tended to become overly long and overly expensive due to a lack of use of nomination bodies and the adequacy of mechanisms to manage the procedures. Similarly, many ad hoc arbitrations are undertaken where the tribunal is specifically named. This may lead in itself to further discussion on diversity in appointments, but definitely not in this panel today. That isn't to say that the tribunals in Africa have not managed their own costs. I believe that they generally try to, but it's often the surrounding factors that have caused unnecessary delay and expense to proceedings, making the capped fee issue almost impossible. I asked myself what contributes to the tribunal being unable to fix cap fees, and touching back on the earlier point. And from my own point of view, my limited research, not extensive research, the common criticisms of arbitration proceedings in Africa, which result in the difficulty in capping fees, are those things that we all experience in adjudications and arbitrations, but significantly more so in Africa, where there's attempts to delay the proceedings by respondent counsel. The appointment of arbitrators that are unfamiliar with the substantive subject matter of the dispute. The tribunal costs, of course, dealing with the dilatory parties and lawyers who import litigation rules into arbitration, the enforcement of the award itself, a lack of clarity in terms of the text of local laws on arbitration, and fundamentally the length of proceedings. And similarly, one of the things that I often see is too frequent recourse to the courts during the arbitration proceedings. Another issue would probably be the repeated appointments of some arbitrators. So the issue of tribunal costs was a popular and repeating theme in the research that I read into, but as noted, this may be as a consequence of the surrounding issues. All of these issues result in difficulty of capping tribunal fees. So if this was a cause and effect discussion, then it may be suggested that the causes wholly contributed to the resulting effect, i.e. tribunals are unable to cap fees or indeed provide certainty in this regard. And that's generally because of the conduct of the surrounding factors. My limited research, however, concluded that the theme of tribunal costs repeats in African arbitrations, and it seems to be a precursor to decisions to arbitrate. If we look at other arbitration arenas and their development, would this allow a move to the capping of fees of a tribunal in Africa? Well, we've talked about the Dubai International Arbitration Centre. That currently includes capped fees and expenses for the tribunal for low value disputes. The benefit of this is that the tribunal and the parties are aware of the fees at the onset, and this may allow greater access into arbitration, which has to be a good process for those who find themselves in disputes. The procedure is marshalled quite well by the DIAC, and it ensures that parties follow the process to allow effective management, therefore allowing the tribunals an effective management of their capped fees. In my experience in acting in these matters, the procedure does work well. And if I am concerned in respect to fees, given the notice in respect to the appointment, then there's no necessary requirement for me to take the appointment. The ACT followed from similar initiatives with the ICC and LCIA, and remember they do act heavily in Africa and the African regions. And if we're going to ask a question whether tribunal members have a subconscious meter running with regard to their time spent, and they simply don't act after the hours allowed have been expended, well, I don't think that is the case. Tribunal members are familiarised with the dispute, and when correctly selected, which is a big part of the process, it may be that they can manage within the allocated hours. And I think they generally would do, and Seamus spoke to that as well. So we've heard from a large extent from the other panels members, so I don't need to debate that too much more. However, in debating it further, it may be that part of the answer rests with the nominating bodies and the procedural agreements. Thereafter, does the balance of the issue rest with the tribunal upholding their duty in the pre and post appointment stages? So if we look at the roles of the nominating bodies, ICC, LCIA, they've made significant strides to driving dispute management and tribunal fees. Suryen talked to LCIA and Seamus talked to the ICC, and with that, the Commission report on the controlling of time and costs arbitration, which some of us will be familiar with. In Africa, the most popular nominating bodies, and I don't say this as being a defined list are the Arbitration Foundation for South Africa, which is commonly known as AFSA, the Cairo Regional Centre for International Commercial Arbitration, Kigali International Arbitration Centre, Lagos Court of Arbitration, and the Nairobi Centre for International Arbitration. The choice of nominating bodies and the provisions in respect of cost management and tribunal fees would most definitely be a consideration for the parties to a dispute and to the arbitrators sitting on the tribunal panel. We go back to South Africa, and I've already mentioned the work of CASA in respect of low-value adjudication disputes, which will be a positive for the dispute industry at that level in South Africa. But I'd also like to mention the work of AFSA, who amended its rules for international arbitration in the past 12 months. And they reflected in Article 10 and Article 12. So Article 10 empowers the AFSA Secretariat to shorten any time limits under the rules. It also vests the tribunal with the power to decide the dispute based on documentary evidence alone, unless the tribunal deems a hearing appropriate, and further allows for judgment to be given in summary form. So that's going to help costs. It's going to help tribunals understand where their fees are and the position in terms of a capping process, if we get there. Article 12 of the rules, that promotes efficiency by providing for the early dismissal of a claim or a defence. So all those jurisdictional challenges we get thrown at in adjudications and in arbitrations, this article allows the tribunal to determine on those facts. So if something is manifestly without legal merit or manifestly outside the jurisdiction of the tribunal, it allows an early escape for a litigant who's trapped into claims or defences that are without merit. And that's before substantial legal costs are incurred and time is wasted. AFSA's new rules came into effect on the 1st of June 2021, and they're a welcome move that will help South Africa's reputed position as an international arbitration seat. And importantly, and that's the most important part, will assist parties in understanding costs and tribunal fees. When I did a little bit more research, Charles, I saw that the top African countries acting as a seat in arbitration are South Africa, Nigeria, Egypt, Rwanda, and the Ivory Coast. And it's not without surprise that they are probably some of the most established bodies in terms of nomination. In conclusion, I'll draw to a conclusion quickly here, Charles, because I know we're under pressure with time. Obviously, I'm picking up on the lessons that can be learned from an evolving dispute resolution process, and that's nomination bodies, and that's the tribunal fees and the capped costs. Seamus talked a little bit, and we see the American Arbitration Association. They have a fixed fee arrangement with proposed stage fixed fees for the pre-hearing, the hearing, and the post-hearing phases of the arbitration. They have a cap fee arrangement with a proposed fee cap for the entire arbitral process. Now, for those who read that document, you'll note that it's not necessarily determinative of a final cost, and there may be revisits to it in exceptional circumstances, but in my view, it's an interesting start. Dean picked up on the fact that if you do have a good case, then why are you worrying about the costs? So why would you worry about the tribunal costs? In summary, Charles, capping of tribunal fees must consider the tribunal itself, their suitability, their knowledge, their experience, the parties, how they're going to conduct themselves, the party representatives, how they're going to conduct themselves, what challenges are they going to throw down before the arbitrator, and in the same way we've seen it with jurisdictions in adjudications. The choice of the nominating body and the procedures to be used. It appears to me that South Africa, Africa in general, is developing the issue of tribunal fees and costs. It's probably a little bit behind some of the other jurisdictions, but that doesn't mean that the arbitrators are lacking in their own toolboxes for controlling costs and managing the processes through. And there's a whole number of those. Maybe I won't debate those now, but I would like to talk to them in a little bit more detail, but maybe I can allow you to continue back to some questions, Charles.
I don't think we're going to be able to go to any questions, are we, Sean? Because we need to leave in a minute.
Charles, you're right. You've run out of time, unfortunately.
Right. Let me thank my panel and leave you with just this thought that the consensus view from all the questions seems to be that the parties themselves have a lot to answer for, or their representatives. And one question which I'll leave you with as a thought that was put forward was, how about adopting a new arrangement whereby the responding party pays the adjudicator's fees, and the adjudicator is given a specific power to award party costs against a party that is vexatious in the way it operates during the process. I'll leave you with that thought. I suspect it will not go down very well with quite a few organisations. Over to you, Sean, and thank you again, panel.